A Florida judge has set a date for the start of former President Trump's federal trial in Florida. Judge Aileen Cannon announced that the trial will begin on May 20th, 2024. The date is earlier than Trump's legal team had wanted, but later than the one that prosecutors had requested. The former president is charged with the mishandling of classified documents in that case. Now, the announcement comes as we wait to learn if another federal grand jury will also hand up an indictment against the former president as a special counsel investigates the January 6th insurrection. CBS News legal contributor Jessica Levinson joins us now. Jessica, let's start with the latest news today. What does it mean that a new trial date has been set in the documents case?
Well, it means that Judge Cannon basically picked a middle ground here. As I think you and I talked about, the defense, President Trump had said, let's not set a trial date. Let's push this out indefinitely, or let's push it out till after the 2024 election for obvious reasons. The prosecution in this case had pushed for a fairly quick trial date, which was December. And she basically, as I said, picked a compromise position. She said, we have to pick a date because when it comes to a trial like this, everything is set backwards. They reverse and engineer essentially everything from that trial date. So she said, we need to pick a date. We need to pick a hearing schedule. But she didn't pick what the prosecution wanted, I think in part because, and she gave reasons, she said there's a lot of evidence here to consider. There are going to be complex motions about excluding that evidence. And the evidence concerns classified documents and documents with serious national security issues where only a few people potentially can even look at those documents. So she said, given the volume of evidence, given the complexity of the pretrial motions, she didn't want to set this in December as the prosecution wanted. So she picked about 5 months later. This was the first big test to see if she was just going to basically rubber stamp what the defense wanted or if she was going to push back a little bit.
Now, Jessica, as you mentioned, it appears that this date is a compromise. I'm wondering if this gives you any insight into Judge Cannon's thinking and how she's going to preside over this trial.
So Judge Cannon has a very small track record, so we can't go on much other than the fact that she did rule on an earlier iteration of this case where she granted former President Trump, a special master. As the 11th Circuit noted and overturned her ruling, he was not entitled to that. So that ruling, I would suggest, is a bigger ruling and maybe more important when it comes to her thinking than a scheduling order. But we do have here a decision that she made where she said no to the defense. And of course, what she did is she picked a date where it's after the bulk of the primary elections, but it's before the Republican National Convention. So it is really, in terms of not just the legal calendar, but also the electoral calendar, it is really a compromise position.
Jessica, let's talk about the D.C. case, another federal case. Tell us a bit more about the statutes that were mentioned in the target letter relating to the January 6th insurrection and how all that might factor into this documents case that is now playing out in Florida.
So the target letter is fascinating in the sense that there were 3 federal statutes that were cited. There's been some difference in reporting about exactly which ones, but it looks like the statutes were based on conspiracy to defraud the United States, which we expected. That deals with trying to thwart the counting of the Electoral College votes. Obstruction, which also deals with trying to delay or stop the counting of the Electoral College votes. And then this Reconstruction era statute, which deals with depriving people of rights or privileges that are protected by the Constitution. And this is, as I said, something that was passed after the Civil War. It was originally enacted to stop Southern whites and members of the Ku Klux Klan from using violence to prevent Black people from voting. In more modern times, it's been used to try and punish people who infringe on what's called the right to an honest counting of your vote. And I think the theory here, which is fascinating and something that not a lot of people have focused on, but I think the theory is that in trying to allegedly create a scheme where fake electors were submitted to the Electoral College, in trying to impose this pressure campaign in Georgia to, quote, find almost 12,000 votes, that if that had been successful, it would have diluted the votes. It would have infringed on or undermined the votes of people who voted for President Biden. And I think the idea is that that scheme, if it had been successful, would have deprived people of an honest counting of their vote. So that's the one we really have to look to see if that statute and the target letter, if there is an indictment, if it also shows up in an indictment.
All right, Jessica Levinson on top of all of it for us. Thank you.